G'day everyone and welcome to video 322 for the Legal Studies guy. Quote today from Susan Butcher. I do not know the word quit. Either I never did or I have abolished it now. Look, always find it a bit challenging when someone's just telling us, don't quit, don't give up, just keep going. And they don't necessarily know our circumstances, but it's more about making sure that we are putting things in place so that we don't get to the point where we have to quit, that we're proactive, that we're, doing things like study timetables, looking into the future, into, the next 3-4 weeks and seeing when we have SACs coming up for classes and things like that, utilizing any spare periods we have at school, all of those sorts of things, so that in a way we don't give ourselves the opportunity to quit. We don't get ourselves into a position where quitting is something that we actually have to consider because we've been proactive and managed ourselves up until that point. So really important to, take stock if you haven't for a while, I guess, at how you are proactively managing your way through year 12 so that you don't have to know the word quit. So today is 322, as I said, key knowledge point 2 from area of study 2 of unit 3, so the civil justice system. And today we're looking at factors to consider before initiating a civil claim. So effectively, before you sue someone, what should you actually think about before you just rush off and do it? Study design gives us 3 to consider: costs, limitation of actions, and enforcement issues. This is a dot point from the study design that was on the old study design but has been cut down. So the old study design used to also include negotiation options and scope of liability as things to consider. So you might see those in some resources around as well. But in terms of directly accessible knowledge, so things that you could get direct questions on, they are costs, limitation of actions, and enforcement issues, which is therefore what we'll focus on today. This is one of those dot points that requires analysis. So I'll talk a little bit about that when we get to this key skills, although we won't have an analysed question today. And effectively, by the end of this video, I'm hopeful if someone comes to you and says they want to sue someone, you'll be able to sit them down and say, hey, these are the things you need to consider. So these are the factors that you should actually think about before making that decision. So imagine a scenario in which you are wronged or harmed. Something has happened to you, be it out in the community, in a sporting club you play for, perhaps at school you feel like you've been wronged or harmed in some way. Before you take the step of charging off to court and trying to win compensation from that person or that business or that party, what should you stop and think about first? So this is just a classic, case of thinking before you act. Before you initiate a claim through the courts and head yourself down that very complex pathway, what things should you actively consider? And as I said, the study design tells us 3 things to consider: the cost of the action. Can you afford to take someone to court and see that process through? The limitation of actions. Are you actually able to? So there are limitations, limitations being hopefully a clear word that you understand, boundaries, clear boundaries around time limits for suing. So we'll talk about that and how you would have to consider that. And then ultimately, is it worth suing someone? Is it worth expending that cost and going through that process if they can't pay? So enforcement issues from the defendant. I like to change the order that the study design gives them and just do them through this order: limitation of actions, costs, and enforcement issues. And the reason being that limitation of actions is a very, in a way, black and white concept. So it's probably, to me, of these 3, the first thing you should consider before you sue someone. So limitation of actions is simply that there is a time limit. And if that time limit expires, you cannot initiate a civil dispute. So if you wait too long after being harmed, you are not legally able to then seek compensation through the courts. Reason for this is range of things. It means that the matters that the courts are hearing are recent relevant. They're not being clogged up by historical matters, but also that there's significant issues with trying to hear historical matters, particularly from an evidentiary standpoint. And that is more likely to prejudice so we don't have to think principles of justice here, but prejudice, thinking fairness, that's more likely to impact on a defendant. So you're more likely to have ongoing records, perhaps of medical things like that for harm that you have suffered. Whereas if it's 15, 20 years down the track, it's actually really unlikely that an organisation, a business might actually have records going back that far. And as a result, they can't properly defend themselves, which means the court process will be prejudiced against them. So really, really good reasons for why we have time limits to make our process ultimately fair, keep the court system moving smoothly, which is all around access, efficiency, and ultimately ensuring with that evidentiary stuff as well that parties are on as equal a footing as possible. We have a piece of legislation in Victoria, so passed by Parliament, called the Limitation of Actions Act, and it basically includes all of the time limits for different types of civil offences, because I shouldn't call them civil offences, sorry, for different types of civil actions, because different civil actions have different time limits. Probably it's not clear how in-depth we need to know these. Past exams have indicated that we don't need to know a list of time limits for different types of civil actions. But probably I would say two that are worth remembering are personal injuries, which is, your basic negligence claim, and is really one of our most common civil claims. It has a 3-year limit, and it's 3 years from the day, effectively, that the cause of action is discoverable. So more or less 3 years from the day that you are harmed. If it's an immediate physical harm, you've got 3 years because you have discovered on that day that you have been caused harm. But also there are some circumstances, it's a very complex legal area, but like asbestos, people who, have breathed in asbestos fibres and haven't maybe suffered an illness until 30 years down the track. Obviously, their course of act or their actionable claim wasn't discoverable in that time previously, and that actually was an out-of-limit claim, which I'll talk about shortly. But yeah, 3 years from the day that your claim is discoverable, or 12 years from the day that the harm occurred. So there are some examples of where you might, suffer an injury that you don't realise for a number of years, and as a result, your time limit starts when you realise. But generally speaking, 3-year time limit from the day that you're harmed. Defamation is only 1 year. It's really tight. And the key reason defamation is only 1 year is because both the evidentiary factor, evidence being recent, relevant to the courts. But in a defamation matter, you have to think it's about, how much your character has been harmed, how much your reputation has been harmed. And that's something that can really only be assessed as close to the moment as possible. The longer you go down the track, how hard is it to figure out exactly what someone's reputational standing was and how much that's been harmed. So defamation only has a 1 year time limit to sue someone. You can sue out of the time limit in some circumstances. So there are, pathways to initiate a claim out of time. But what you have to do is you have to apply to the court in those circumstances. You have to be able to show that you have acted reasonably. You have to be able to show that there were reasons why you couldn't file the claim earlier. And the court has to consider how that will prejudice the defendant by having to try and defend an action out of time or out of the limit. So generally speaking, black and white, you have a set period of time, and you need to think about that if you're going to, initiate a civil action. If you feel like you've been defamed, you can't sit around for a couple of years going, oh, should I, shouldn't I? You have to action that within 1 year. Same for a personal injury. You have to action that within 3. So it's a really important thing to consider. before suing someone, making sure that you actually still can. Let's say that you've considered that and you're within the time limit. It's been a year and a half since you suffered some kind of harm, and you're at the point where you're like, yep, I've worked through that, and now I want to get some compensation for the harm. The next thing to consider is how much it's going to cost you. So, thinking back to criminal law, we talked about the impact of costs. We're going to talk about that later on in civil law as well. And it's really a similar issue. Legal representation is incredibly expensive. Filing fees in the courts are incredibly expensive. You might need to bring in expert witnesses. You've got to pay hearing fees. You've got to pay effectively to use the courts. You've got your lawyers' fees, solicitors. You might need to bring in a barrister on the day of your trial. All of this adds up, and you need to consider what will happen if you lose. Not only might you need to cover your own costs if you lose, you might be required to cover the costs of the person you have sued, because you have taken them to court. They have had to spend a lot of money to defend themselves. They've done that successfully, proven or shown that they're not liable. You've been unable to show that they are liable. Therefore, shouldn't you have to pay some of or most of the costs that they've accrued to defend themselves? If you win and prove that you've been harmed, you actually might be able to get a portion of your legal fees covered by the other party, so you can get a costs order, but you have to go back to court and argue for that after the fact, and it's likely that won't cover all of your costs. The court will consider that and consider what your costs were, where they came from, what's appropriate to make the other party pay. So you might actually, even if you are successful, you might actually lose some of your compensation to the costs that you had to pay. So you really need to consider if it's worth it, not to mention the time cost, the stress of going through an extensive legal process, plus the monetary cost, all adds up to be like, you need to make sure that you are willing to risk that and go through that in pursuit of your claim. Is it actually worth it? And ultimately, if you win, if you decide you can afford it, is the other party going to be able to pay? What if you win and you're seeking compensation and they won't pay, or they don't have the ability to pay? Is that worth it? Has that been worth your time? Now, some people would say, yeah, like, I'm happy to spend the money to get that moral victory, to get that sense of vindication that a court has shown that person wronged me. But for others, it might not be worth that stress, strain, trauma, and monetary cost to prove that you've been harmed by someone, but then not actually get anything for it. Now, judgments can be enforced through things such as garnishee orders or examination notices. So garnishee orders are when they take some of the defendant's pay, for example, over an ongoing period of time to pay you back. So in a way, they're on a payment plan. An examination notice is when they can actually then examine all of the assets and property and things like that a person owns, and ultimately potentially seize some of it and sell it, and then give those proceeds to you to cover the damages. So you've got to consider that there are multiple ways to get paid, but each of these things take more time and they take more costs to apply for. Getting the judgment of a court enforced is sometimes not as straightforward as just the court handing it out. You might have to go back to court to get support with that. It all adds to the process. And again, you need to think about these enforcement issues, and if it is worth the cost, time, and effort for maybe a defendant who is not willing or not able to pay. And often this is why there are things like we talked about in criminal law. There are things like victims of crime, assistance tribunals to try and give you some of your costs you've accrued back. There's also the ability to give out compensation orders through the criminal sentencing process to try and avoid perhaps enforcement issues that could arise through a subsequent civil action and the load on the courts. Ultimately, if you are thinking of suing someone, if you are sitting there right now being like, do I have a course of action? Have I been harmed? You need to remember or think, am I within the time limit? When did it happen? What's the date now? When would I have to sue by? Can I afford it? Unfortunately, for some of you watching this, probably no, as students, even as a teacher on a wage. Depending on the matter, it's probably a challenge for me as well. And can they pay? And will they pay? And is that worth the extra effort that it would take to try and enforce the action? The key skill here is analyze. We know an analysis is like a super explanation. So we need to, if we're asked to analyze any of these factors, generally against a case study, we need to go into just, more detail as we try and explain and then look at, the facts and the issues in more detail. But you could also just get sort of a question, say like this, a little case study question. Ignatius suffered a broken nose as a result of a brawl in a recent football match. The opponent who allegedly punched him is unemployed and claims that he didn't commit the act. Ignatius is considering initiating a civil claim to recover the costs of his medical treatment. Outline one factor he would need to consider before initiating this claim. You could make that worth more marks and change the outline to an analyze. Could be analyze two factors. But effectively, what we're assessing here is a skill, and both that synthesis skill to apply legal principles to hypothetical scenarios, is that idea that you can pick things out like the opponent is unemployed. So one factor that Ignatius would need to consider is perhaps enforcement issues. Even if Ignatius is able to take the opponent to court and prove that he did punch him, even though the opponent has said that he didn't, the fact he's unemployed might mean he cannot cover the cost of Ignatius' medical treatment. And in a way, even though garnishee orders could occur, unemployed, so garnishee order wouldn't work, an examination notice, ultimately, is it worth the effort when Ignatius might be able to recoup those costs in other ways? So just trying to pick out factors of a case study that apply then to the features of a case study, that apply then to those factors is one of the key skills that will be used or assessed for this key knowledge dot point. In terms of actual scenarios, this is a criminal matter where 2017, where a kid was thrown from a ride at the Adelaide show and they died. The owners of that ride were pursued through effectively work cover. This is in South Australia. And ultimately, pursued criminally and pled guilty. And they were given in total a $157,000 fine. But the workplace regulator acknowledged that the owners of these rides were in such significant debt and had no cash flow that they were never going to be able to pay the fine. And this would be a classic example then of the family of the girl who died. Probably enforcement issues is a big deal here. They can't pay the fine for the criminal action. Is it worth us seeking compensation when it's unlikely that we'd be able to receive any? So might be worth having a look at. In conclusion, if you want to sue someone, what should you consider beforehand? Hopefully you now understand that you should consider how much it's going to cost you, whether you actually can initiate the claim or not, and then what happens if you win but the other party can't pay. As always, feedback below. But happy studying.